Hey guys, hey chat, hey replay crew, if you're going to watch this on replay. We are starting the live a little bit earlier than I scheduled it, but we have a new motion. It is a writ of mandamus filed with the Supreme Court of the state of Georgia. Now what that means is with a writ of mandamus, in this case, it's Diamante Kendrick's attorneys, Douglas Weinstein, Katie Hingerty, and Jay Apt. They are asking the Georgia Supreme Court to order a trial court judge, in this case, Chief Judge Ural Glanville, to follow a rule that he should be following. Specifically, this Rule 25.3, which is, if a judge is presented with a motion to recuse, disqualify, and there's an affidavit that on its face, a prima facie consideration, there's sufficiency of the evidence. There's enough if you take it at face value, that the elements that would warrant a recusal are met. And if you watch any of these other streams or follow any of the news last week, we've all been in agreement that there's enough there that Judge Glanville should consider recusing himself. He denied those motions. So now what we're going to look at today is this motion, this writ of mandamus, which is going to ask the Supreme Court, since Judge Glanville will not follow this rule himself, we need you to order him to do so. So here, we're going to go through it. Shout out to Amina, by the way. I see you're here early and putting off sleep for this. Shout out to Drea. Shout out to EC. Good to see you, EC. We're going to go through it. It looks scary because it says 83 pages, but it's only about 27. There's just all of the affidavits that we've read throughout the last week attached as extra evidence. So let's get into it. Let me make this big for you guys. Stretch this window out. So yeah, definitely not going to be reading 80 pages, although if you guys are interested in it, the written motion from Judge Glanville denying the recusal motion, that's attached here. So if you want to read that, we can look at that as well after we get through this. So let's do that. Hey QT1, by the way. Hey Ann Steph. Kiana Shaw, good to see you. This just came down, and Kathy Roussan, I'm glad you posted that. Shout out to Kathy Roussan. She posted it on X. I think she's been in the courthouse, so she was able to grab it. But this was just filed like an hour ago. So that's how we're able to look at it. But let's see. We've got a table of contents, which is always really nice to see. Table of authority. So these are all the case law, the cases that they're going to be referencing. We see the famous Baptiste that Glanville tried to cite in court last week, saying it supported his denial of the motion to recuse. And we've got all the same rules we've been talking about as well. So comes now Diamante Kendrick, by and through his undersigned counsels, and brings this emergency petition for writs of mandamus and a stay of proceedings, showing as follows. Now they're going to explain why the Supreme Court is the correct place for them to be asking, and why it's an emergency situation. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioners' state and federal constitutional rights. This petition relates to the conduct of Chief Judge Glanville, and not to any rulings or orders of the judge. Now, this is really funny because this is why Chief Judge Glanville tried to say he was denying the motions to recuse. He said, you can't just ask me to step down because you don't agree with a ruling that I make. But here, the actual issue they're clarifying is the conduct. Judicial misconduct. That's the reason for this want for recusal and why we need the Supreme Court to step in. This court has jurisdiction over this matter under Georgia constitutional, and they're going to say that we have nowhere else to go. So in the case at bar, original relief in the forms of motion for recusal have been filed and denied 3 times by 3 respective movements. Likewise, Glanville has denied the movements' respective requests for a certificate of immediate review 3 times. Glanville, as chief judge, has obstructed defense counsel's attempt to have a disinterested party review the numerous allegations contained in at least 4 affidavits, which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Now remember, the sufficiency of evidence standard, that this initial request to recuse, it only needs to be considered at an if true level. Judge Glanville said, nope, it's not there. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance in refusing to provide a transcript of a secret ex parte proceeding, Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse, unless or until the underlying case was concluded. Because remember, Glanville said, take it up on appeal, which this trial is expected to go like another year, 2 years or more. Not a very quick remedy. Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for abuse of discretion. Glanville's obstruction of defendants' rights to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied. 2 writs of mandamus are already filed and attached to the instant case, which were filed and pending for more than about 1 year. And they write here that this is related to the search and seizure of Jeffrey Williams' property. Now, I believe there was the jeweler. This is the jeweler here, claimant Raffaello and Company, because there was like jewelry and cash in the amount totaling over $100,000. The jeweler actually had filed this complaint, this motion, like it was rented. So you seized Young Thug's property, but that's not really their property. So this party, separate from, he's not a defendant. The jewelry company is not a defendant. They made filings with the court and said, hey, can you pay attention to this? And according to this, it's still pending a year later. It hasn't been closed out or dealt with. I have another video that dives into the civil seizure, property seizure issue in Fulton County. But just know at a top level that it's been a contentious topic over the last year. Therefore, any effort to file a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of action. Glanville's court is where writs go to die. What? I'm not saying that. That's on the filing. They said Glanville's court is where writs go to die. That's hilarious. As the present petition for writ of mandamus would go to Glanville if filed in Fulton County Superior Court, Petitioner has no option other than for the Supreme Court, the Georgia Supreme Court, to exercise its discretion and consider defendants' claims. A secret ex parte proceeding was held on June 10th. In attendance were Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. Now, Kayla Bumpus did an interview with Talk That Law. I'll update the stream and put his channel link in the description, but you can find it. It was a new video. It was like 2 days ago. But Kayla spoke with him and said there were 14 people present in this ex parte meeting. So there were 14 people present, yet they still don't let anybody know on the defense team that it happened. So that was a little interesting detail there. As a result of this proceeding on June 12th, Petitioner requested that the presiding judge, Glanville, recuse himself. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following. Now, they have this footnote here that's saying that the claimant hasn't agreed to any delay in the hearing of its petition, and in the meantime, the claimant is without over $1 million in their property loaned to Mr. William for his performances. So I didn't realize that the footnote above continued, but that's actually crazy, because it's adding that there's $1 million that was still in this pending proceeding relating to civil seizure of Jeffrey Williams' property that was really rented jewelry from this company. I only thought it was like $125,000, but apparently it's over $1 million worth of property that belongs to this jeweler that Fulton County just still has. So that's crazy. So Glanville denied a request for the certificate of immediate review, which would have streamlined. They wouldn't have needed to kind of make this emergency request if they had their certificate of immediate review. A certificate of immediate review would be the trial court saying, hey, I can't rule either way on this, or I'm not going to rule on this either way, but basically here's a pass for you to take it to a higher court and ask for them to review it right now while everything else is still going on. So that was denied by Judge Glanville. A formal order denying the motion was entered on June 14th, 2 days after the motion for recusal was filed. As Chief Judge of the Fulton County Superior Court, Glanville holds a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writs is petitioner's only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for another year, at least another year, or more of trial, before seeking appellate review. The appellate procedure in the case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. Emergency relief is requested because the witness that was coerced by Glanville, and that's a flat out, there's just saying it, the witness was coerced by the judge. Top-level misconduct is presently on the witness stand. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as the coercive joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland. So we are a few days away from that. They spent all day today discussing what parts of different police interviews to let in. But once we get through that, we're a couple days out from the defense starting their cross-examination of Woody, who is the witness at the center of this ex parte, I don't even know what you want to call it anymore. Scandal really seems like an okay word to use. So they need the emergency relief. They need the Supreme Court of Georgia to come in and do something, because it should not be Judge Glanville that's making decisions if the defense wants to raise an objection or has an evidentiary issue when they're about to cross-examine their witness, let alone they don't even have in front of them, disclosure of things that they should have been disclosed, things that Woody could have said during that ex parte meeting, or agreements that were made with him, or admissions, claims that he was going to lie if he was asked about certain things. This all needs to be remedied before the defense cross-examines this witness, because they all have a constitutional right to properly confront this witness. So it's a big deal. So what's the relief sought here? As Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3, and thus, and this is coming from Rule 25.3, Judge Glanville was supposed to do this: assign the motion for recusal for hearing before an unbiased judge. That's what the rule says he should have done. He didn't do it, even though he was asked more than once. So, Supreme Court, this is relief that we're seeking from you. Order Glanville to do so. Get this in front of an unbiased judge. Petitioner further asks this court that proceedings in the trial be stayed pending resolution. So this is the underlying case. Be stayed pending resolution of the motion for recusal. Petitioner further asks this court for a writ ordering Glanville to produce immediately, and certainly no later than prior to the start of cross. What do you think's coming, guys? An unredacted transcript to defendants of the secret ex parte proceeding held on June 12th, 2024. Is that a typo there? I think that should say June 10th, so maybe they should amend this. Petitioner also asks of this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. Whether Glanville was correct in failing to follow the mandates of 25.3 by refusing to refer the motion for recusal to an unbiased judge for hearing following argument on June 12th, particularly after making findings in an order of June 14th that the motion was timely, the attached affidavit was legally sufficient, and that the affidavit contains assertions of fact to support the allegations of bias and impartiality. Now, they're going to go through the procedural history. So again, this is being written by Diamante Kendricks, and there's a typo there too, his attorneys. But they're going to say, look, this started all the way back in January with November with jury selection. But then following the secret ex parte meeting on June 10th, Petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein. Now, an affidavit, that was an important attachment because it's sworn. That's the statement, essentially, of facts that are supposed to be taken at face value as Judge Glanville's weighing through things to see if the sufficiency of evidence is met. So all of that stuff that we read signed by Douglas Weinstein saying, upon information and belief, I heard that, Prosecutor Hilton and DA Love, they were offering a deal. And they told Woody that they wouldn't prosecute him if he lied. Those were all those sworn underlying statements. So they had given this to Glanville on Judge 12, and the motion to recuse was based on the impermissible secrecy of that ex parte proceeding and the violations of the judicial code, because Glanville was part of that meeting. But then the motion was summarily denied, right then and there, with a formal order issued on June 14th. Now they're going to get into this secret ex parte proceeding itself. A central figure, perhaps the central figure, in the state's case against Kendrick and the other defendants is Woody, Mr. Kenneth Copeland. On Friday, June 7th, 2024, Copeland was sworn in after being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify. Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Now, you guys all in the chat, a few of you guys suggested that weekend was his daughter's birthday and that they may have known about that, and they were really trying to poke and prod at him, knowing extra sensitive information that incarcerating him for that short weekend would be problematic, even if he normally wouldn't have cared about being locked up for 2 days. That's just something I heard from you guys that I thought was a great detail. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of defense counsel, an ex parte proceeding was held in Glanville's chambers on June 10th, 2024. Among the attendees were Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No member of defense counsel was present, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of the trial. Neither Glanville nor any member of the court staff, nor the Fulton County DA's office, made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. Now, if this seems repetitious because we've been reading all these motions, they've got to lay all this out in their argument to the Supreme Court to say, here's, the underlying, here's the background of everything. We already went through, Judge Glanville not doing what he was supposed to do. But they do have to lay all of this stuff out for the Supreme Court. So that's why we're repeating it again. One or more members of defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor from the DA's office. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. So upon information and belief, we're going to get these bullets, but they're huge bullets. I don't think it doesn't feel like a waste of time to repeat them. They're so huge. They shouldn't have happened in the first place. So let's say it again. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than to testify. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Glanville working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the meeting. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that is yet to be provided to Kendrick. So this is a new line. We knew that, we suspected that, we've talked about that, but here, this is filed today. This was just filed. If you're watching this on replay, crew, like a week from now, it is June 20th. This Brady material still has not been disclosed, at least not to Kendrick's attorneys. So that's a problem for the prosecution, right? This writ isn't dealing with the prosecution at this point in time, but, you know, I'm glad that they put this in here. They still didn't make disclosures. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. So yeah, just go ahead, suborn some perjury. Important Brady material that is also yet to be provided to Kendrick. So my guess is that they've still disclosed nothing about this meeting at all to the defense, because these are two important key points, and they have not been disclosed. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr., important Brady material that has not been provided to Kendrick. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify he killed Donovan Thomas Jr., Hilton told Copeland that she would prosecute him for perjury if he testified he killed Thomas. Important Brady material still yet to be provided. So still no Brady disclosures, you guys. So either they must be going for flat out denial, or they're just trying to look the other way and wait for time to pass and hope nothing happens. Like, either way, that's not good. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate, and good, they're calling it out, it also demonstrates an illicit effort to repress Brady material that should be provided to Kendrick. Now, this is huge if you can remember the extra layer that the judge doesn't want to turn over those transcripts until appeal. He's kind of seeming like he's wiggling in his seat a little bit on the transcript issue. He said maybe he'll turn something over on Tuesday next week if it's ready, with redactions after he goes through it. Doesn't sound like he wants to turn over the complete transcript, and he's not promising it'll, for a fact, be turned over by Tuesday. But in any case, he still initially said, you can wait until appeals for the transcript, which suggests he was willing to let Brady material go undisclosed. Attorney Kayla Bumpus, by and through her counsel, filed a motion to quash order to show cause and motion to recuse on Friday, June 14th, which substantially supports the Weinstein affidavit. Really, the only difference in the affidavit part of Kayla's motion, she didn't specify the statement from Woody, well, I'm going to testify that I'm the one that killed Donovan Thomas. That wasn't part of her affidavit, but the rest was there. So, yes, substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus's first-hand account of the misconduct is credible. The facts attorney Bumpus asserts, and then, okay, cool. So this is actually good to know. So they're citing Parrish v. State, and noting that assertions made by a party's counsel are treated as if they're made by the party themselves. So in other words, treat attorney Bumpus's statements as if they were Woody's, at least relating to that small window where she was representing him. So Bumpus says, which is as good as Woody saying, on Monday, June 10th, at approximately 8:30 a.m., Mr. Copeland and his lawyer, attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify. Those present for the substantive portion of this ex parte proceeding were Glanville, Copeland, Bumpus, Love, and Hilton, members of the court security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced he planned to reassert his Fifth Amendment privilege. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. Copeland cautioned that his testimony would be a lie. Now, we're going to get into events in the court about the time of the ex parte proceedings. This sounds like the oral arguments when they're all crashing out, but I do want to thank, Jorge, thank you so much for becoming a member, and Amina, just for the love of the game, $5.99. I love that. That's so nice of you, and I'm so grateful again that you are staying awake to tune into this, because I don't remember exactly where you are. Are you in England, in the UK? But I know me, when I'm delaying my sleep, I get cranky. So I appreciate you so much. Now here we're going to talk about these events. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m. Admitted entrance into courtroom 1C and seated by 9 a.m. So we're all on time, Judge. And you told us we would know at 8:30 in the morning if Woody was going to be willing to testify. So we're there waiting to find out. And then just so I don't miss your message, so Paris, thanks for correcting me. Exhibit A, Weinstein affidavit, is cited there. Defense counsel waited and waited. And we saw the same language in Douglas Weinstein's other motion. Between 11 a.m. and 11:30 a.m., Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for the delay, providing Glanville an opportunity to reveal that the ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempts to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, citing Rule 16, Glanville held Steele in criminal contempt and sentenced him to 20 days of incarceration. And we know, again, if you're tuning in late, this writ of mandamus is being filed by Douglas Weinstein, two other attorneys, to the Supreme Court of Georgia. The Supreme Court of Georgia is already familiar with this matter, in part, because they've already heard and granted a motion filed on Brian Steele's behalf for supersedious bond. Meaning, don't make him actually do these weekends in jail. So Brian Steele never actually had to sit in jail and turn himself into custody. So this footnote here is just going to cite that decision. Now, Glanville's hearing on the motion to recuse and subsequent order. On June 12th, Kendrick, that's us, filed and presented to the court his motion to recuse. During the 10-minute hearing, guys, that's a good way to throw shade. They're basically saying, you didn't hear it. You didn't really address it in full. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint against his previous rulings. And are they going to quote him in this footnote? Oh, they're going to say, here's the YouTube video. But yeah, he addressed those motions. And one of those motions was a motion from Kayla Bumpus's attorney saying, we want you to recuse yourself from the order to show cause hearing, that leg of proceedings. And Glanville just mushed it all together and was just like, yeah, just because you guys don't like my rulings isn't a good enough reason to ask me to recuse myself. Glanville ignored the subject matter of the motion and the affidavit, which was an accusation that on June 10th, a secret ex parte proceeding was, 1, in violation of at least Section 29 of the Georgia Code of Judicial Conduct, which assures that every person, including defendants such as Kendrick, a fair hearing, and 2, in violation of Rule 211 in the revised Georgia Code of Judicial Conduct that generally states, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. During the June 12th hearing on the motion to recuse, Glanville refused to conduct the timely analysis required. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Weinstein requested at the time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated that an appeals court, years and years down the road, could look at his denial at the conclusion of the trial. On June 14th, Glanville issued an order on motion to recuse Chief Judge Glanville. And let me know if you guys want to look at that after we get through this one. I don't know how long it is, but it is attached here as an exhibit if you want to take a look at that in full. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by Rule 25.3. So once again, the main rule that we keep asking Judge Glanville to follow, another way he didn't follow it. The court found all 3 prongs satisfied, and the analysis should have stopped there. But Glanville did not. Yeah, I want to read that now. Because in court, on the floor, he acted like 3 was not satisfied. The sufficiency of the evidence was not satisfied. But now apparently this is the second time they've said it in this motion. In his written motion, he says, yeah, everything you need to show me is met. But I'm going to deny it anyway. So maybe we should definitely take a look at that. Applying the wrong standard and reaching the wrong conclusion. Oh, this is the part. This is where the shenanigan is going to be. Judge Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. Why is there lack of evidence, you guys? Why is there lack of evidence? Let's think about that. Why is there lack of evidence that would support the claims in these motions that have been denied? These claims that, hey, something funky happened in that ex parte meeting. Oh, well, I can't consider your motion for me to recuse myself over that because you don't have evidence of it. Well, is that because you wouldn't let them look at the transcripts until the appeal? Like, it's a way to dance around the elephant in the room. We definitely need to look at that full motion, the full order from Glanville on that, because this paragraph is wild. And I wanted to stop and say thank you so much to Rubber Toe for gifting memberships. Guys, if you got a membership gifted, say thank you in the chat to Rubber Toe. And if you're just appreciating him for supporting the channel, supporting the content, show Rubber Toe some love. Appreciate that so much. I love the gift feature on YouTube. So yeah, because we don't have the transcripts. You guys got it. You guys got it. And Danny Steele. So yeah, he said he's going to review them and reveal and remove what he feels needs to be redacted or whatever. It always seems like there's always something. So let me make this giant again. And then argument and citations to authority. Now, I like case law. I like seeing what's cited. I like seeing what already exists. I like here, it seems like we're going to get a lot of cases that are coming not just from Georgia district cases, but Georgia, some from this Supreme Court, which means it's going to be binding. It's not just going to be persuasive. A lot of this case law is going to be, you guys ruled this way, and this is a similar circumstance, so you should follow what this case law says. And I particularly like this in this case because we've seen Judge Glanville and the prosecution kind of go like this with case law. The defense will try to cite something and they'll be like, oh, well, we don't think that that's what that says. Even today, I think in court, Brian Steele had to push back against the prosecution because they cited a case. He was a lawyer on part of that appeal that they were citing. And the prosecution tried to give an interpretation of the appellate decision that would favor them. And Brian Steele's like, no, I was like part of that case. That's not what that says at all. What are you talking about? So I feel like Douglas Weinstein might be about to slap them with some case law here. So under Article 6, and why do they do it that way? Well, you know me, I'm bad at reading these things. This court has those powers, quote, necessary in aid of its jurisdiction, including the power to issue process in the nature of mandamus and injunction. So this is, citing the jurisdiction. Then the Code of Georgia allows parties to seek mandamus to compel due performance of an official duty where a defect of legal justice would ensure from a failure to perform or from improper performance. And there is no other specific legal remedy for the legal rights. So they're saying constitutionally and statutorily. We've got two different documents stating it out, that this is a remedy available to us, if not a duty for you to grant this remedy for us. To compel removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. Now, Code of Georgia also says that to preclude mandamus, The alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. And that's Blaylock v. Cartwright. Now, they have to say that Glanville has failed to follow this rule because he wouldn't put it in front of another judge. So he's not following the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, so on its face, is it sufficient on its face, would warrant the assigned judge's recusal from the case. Glanville failed to follow that during the hearing, this motion to recuse, according to Rule 25.3. Glanville, following the filing and presentment of the motion to recuse on June 12th, failed to make the required determinations under Rule 25.3. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court. Guys, we called that out when he said that in court. We're like, that's not what this motion is about. Instead of recognizing it as a list of incidents of judicial misconduct by Glanville. So this isn't an issue of judicial discretion being misapplied. This is an issue of judicial misconduct. And Glanville's like, well, we're just going to look over this way. Glanville curiously clings to Baptiste v. State. He sure does, as supporting his contention that the Weinstein affidavit does not merit recusal. But there is no support in Baptiste for this position. In fact, Baptiste supports Petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a fair trial uninfluenced by the court's prejudgment. I'm glad they called out this thing with Baptiste. I mean, you can kind of just guess the way Brian Steele got up to the podium after the judge had cited Baptiste. He got up there and he's like, in regards to Baptiste, he was ready. Glanville failed to follow USCR Rule 25.3 in his order on June 14th, which we could read in full. Glanville's order of June 14th contains a critical error of law. The law requires that when making a determination under Rule 25.3, the court must consider whether recusal would be warranted, quote, assuming any of the facts alleged in the affidavit to be true. Assuming any to be true. A judge is not allowed to pass on the truth of the allegations in the affidavit. Instead, Glanville properly found that the Weinstein affidavit, quote, contains assertions of fact to support the allegations of bias and impartiality, which by law should have ended this inquiry. Glanville must then refer the recusal motion to a neutral judge to decide the merits of the motions pursuant to Rule 25.3. And again, it's really this rule that's the center of this writ of mandamus. You know, the writ needs to cite something, a rule that a judge is not following. Show why it's not being followed and what they need, in response to this writ. What do we need you to do to come down here and remedy what Glanville's doing wrong? So that's why they keep going back to Rule 25.3, because it's the basis of their argument here. So got to get this in front of a neutral judge to decide the merits of the motion. Glanville's factual review of the Weinstein affidavit is particularly astounding, given that Glanville has repeatedly refused to give defense counsel access to the transcript of the ex parte meeting. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of one of our source, and to issue an order to show cause to attorney Kayla Bumpus in an attempt to silence her. Now, this is actually pretty interesting, too, because we're seeing here, they're saying that this order to show cause was to Kayla, and we've all said, it seems like he's singling out Kayla. Kayla's response to this order, she filed a motion to quash this order to show cause. In her response, she's like, why are you singling me out? You only name me and Woody by name. You don't mention anybody else by name. And here in this writ of mandamus, they're really highlighting that this order to show cause was meant for Kayla specifically. While Glanville's views appear to be evolving over time, Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. However, at this point, Glanville is still indicating that any transcript provided will be redacted to remove, quote, privileged information. What could be privileged in a proceeding with 14 people? In a proceeding among Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. Glanville failed to follow Rule 25.3. Proper procedure requires referring a motion to recuse to an unbiased judge after the 3 prongs of Rule 25.3 have been met. So, Glanville, and we've established this in our own discussions here, guys, but Glanville has violated multiple rules of Georgia Code of Judicial Conduct. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal be warranted. The details learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. And we've read this rule a bunch of times, guys. It's from Rule 4.1, this footnote here, but it's, ex parte communications are generally prohibited, and then there's all these exceptions. And we've gone through them, and these exceptions do not apply to the situation being alleged. Ex parte hearings are only authorized in the case of extraordinary matters, such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing, with an opportunity of attending and voicing any objection that may be properly registered. So, I think it's good to remember Rule 4.1 there. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Rule 2.9 of the Georgia Code of Judicial Conduct. Oh my god, you guys yelling? I'm so sorry. I just looked over here. Thank you so much. Appreciate you guys. If you guys want me to loop back, let me know. I'm a struggle streamer, you guys. I was here, though. We can redo this because this was really the important argument that we just looked at. The violations, multiple rules of the Georgia Code of Conduct. And we're violating, this Rule 4.1. This ex parte meeting, there wasn't really an exception for it to take place in the first place. And then also Rule 25.3, that if we present this to you, if this shouldn't have happened, you should be considering a motion for recusal on its face, if this type of thing is being alleged. So, wait, I'm missing a sentence here. So the secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person has a fair hearing. Ex parte communications are presumed to have been in error. And that's Pendergrass versus Skelton. See also Exhibit C, so we might have more there. Not only did Glanville fail to notify defense counsel about the ex parte proceeding, as required by Rule 2.9, but Glanville made every effort to conceal the proceeding. As attorney Lester Tate states in paragraph 14 of his affidavit in Exhibit C, in reviewing the video of the exchange, so we're going to have to look at this exhibit too, but in reviewing the video of the exchange between Judge Glanville and attorney Steele, there was no disclosure of the ex parte proceeding, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might have already disclosed. Georgia Code of Judicial Conduct Rule 211 says, generally, that you could learn all the key rules of judicial conduct just by reading what's going on with Judge Glanville in this YSL case. And that's rule after rule they keep citing here. So, this Rule 211 says, generally, that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person, rather than from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence at the case is at issue. So in other words, the judge is obviously falling under the category of an interested person because they are a party themselves. So, furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. Because remember, in these affidavits, it was Judge Glanville, they're saying, gave the Georgia rules of perjury. He put the documents in front of Woody as if to nudge him. Wink, wink, this is what could happen to you if you don't do what the prosecution's asking you to do. It was Glanville that put those documents in front of him. So, Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. And they cite multiple cases here, so Wynn v. State and Benton v. State. As this court wrote, we need not decide whether, and they're citing a Supreme Court of Georgia case, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whether their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyers. And that's Johnson v. State. And then defendants were not provided notice of the hearing, which, they were all sitting there just like twiddling their thumbs waiting. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness into testifying. As the motion to recuse met all requirements of 25-1, 25-2, and 25-3, Chief Judge Glanville must assign the motion to recuse to another judge for consideration on the merits. So they're going to say that his failing to follow 25-3 violated Georgia Code of Judicial Conduct 2-1. Now, this rule states that judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence. Do you guys have public confidence in the independence, integrity, and impartiality of the judiciary? You guys are the public. Do you guys have confidence right now in this? In the hearing of June 12th, Chief Judge Glanville failed to follow Rule 25-3 by failing to make, I think we've got a typo, by failing to make, I'll forgive them though, because I think Doug Weinstein was sick, right? He tested positive for COVID a few days ago, and maybe the other counsel that he works with, they're doing this while dealing with being sick. But by failing to make determinations required in a timely fashion, Petitioner need not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12th and June 14th, were a violation of Rule 2-1 of the Georgia Code of Judicial Conduct. So, then the conclusion. Glanville's actions offend public confidence in the independence, the integrity, and the impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. So as Attorney Tate writes in paragraph 15 of his affidavit in Exhibit C, which we'll go look at that in full, but we have a paragraph pulled here. Here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, and who, also, has actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and, assuming it to be true, would require recusal. Again, I reach this conclusion based on Judge Glanville's actions, not any ruling that he has made in the course of the trial. Because again, his rulings were not the subject of these motions to recuse. Petitioner requests that this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted, yes, give us the full transcript. Give it to all the defendants of this secret ex parte meeting. Petitioner further requests that proceedings in this underlying trial be stayed pending resolution of the motion for recusal. Petitioner also requests this court enter any further writs or orders it deems appropriate given Glanville's actions. So again, guys, this was filed today, 20th of June. And they're noting, this submission does not exceed the word count limit imposed by Rule 20. So you've got, again, Douglas Weinstein, Jay Abd, and Katie Hangerty are the attorneys that filed this writ of mandamus. I think Exhibit 1 here, is this their own motion to recuse? So Exhibit A is Doug Weinstein's motion to recuse. Now that was a long one. And then Exhibit B. Oh no, that's part of Exhibit A. You got his affidavit as part of the motion to recuse. And then Exhibit B is Judge Glanville's order on the motion to recuse Judge Glanville. So this, I think, is going to be worth reading. Let's hop over here and see what you guys are saying a little bit, catch up with you guys. Again, apologies for my struggle streaming and keeping the rule on the screen forever earlier. My bad, guys. My bad. I'm always nervous about jumping in randomly and feeling like I'm missing the context. But let's see. Tamika Jones says, "Hi, Kat. I watched an interesting interview yesterday regarding Glanville and others. Please check out Judge Joe Brown's podcast from yesterday and listen to what his special guests have to say. Is one of them named Dana? One of his guests, the real Dana? Because right before I saw this writ of mandamus come down, someone recommended the real Dana in a comment on another video. And I pulled it up to save it for later. I didn't get to watch it yet, but when I pulled it up, Judge Joe Brown was part of the panel. So that's the second recommendation for this interview, I think. So I was going to watch it anyway, but for you guys in the chat, I'm giving it an extra, like, indirect vouch because someone else has recommended the same thing. So that'll be interesting. And I saw it on the real Danish channel, but I'm assuming Judge Joe Brown, they probably both streamed it. And then, let's see. Hey, you guys are having great conversations. I'm so happy to see it because I love YouTube chats. Yeah, so Elaine Gaskins. So other witnesses are saying that they didn't want to testify. Now, I keep thinking all week about YSL Slug. That's Trontavious Stevens. And, you know, by the time he was on the stand, the defense was already aware of, you know, his plea agreement and all that. That was actually disclosed to him. But they were able to have a very effective cross-examination on YSL Slug because this proper Brady disclosure was made to defense counsel. They were like, you know, were you asked, did you have to sign on something that would say you agree not to testify truthfully about any of the defendants named in this indictment? So the jury got to hear the weird terms of that plea deal. And that's always the instance I think back of with, you know, witnesses. He's not the only one that has a plea deal. But the jury got to hear it. And in this case, we're dealing, in this situation, this incident with Woody, it's something that we may not have even known about. That he was threatened with 2+ years of incarceration. Not just for not testifying, but for not testifying what they want him to testify to, and not testifying to what they don't want him to testify to. So, did this happen with somebody else? Is it only Woody? Because happening once is bad enough. But did it happen with somebody else? And there was another witness. It was a female witness who, was it Detective Gaither? I always get their names wrong. But a female witness felt like she was being sexually harassed by the detective that was supposed to prepare her for this case. And, like, just those two examples alone, is there integrity? Is there credibility remaining in anyone who's left to testify? Are they being harassed while they're approaching when they're supposed to testify? Are they being pushed, prodded, possibly coerced into testifying? Is the defense properly receiving disclosures on any agreements or happenings in witness prep that should be relevant to them? Like, there's just so many issues coming up with this. And I don't blame anyone that's still out there that's supposed to testify for wanting no parts in this whatsoever. I don't blame them. I don't blame them at all. And I want to say shout out to the what, why, and who. Those are good questions. Love from Australia. I'm riveted. Love your channel. So awesome to see you here. My palm tree's kind of cut off, but I'm all the way here in Florida. It's hot here as always. So I appreciate your super chat. Australia seems super cool, and I want to visit someday. And then you guys are saying no confidence whatsoever. And then, hold on. I gotta look for a comment from Robert. Robert. I'm scrolling up. Maybe I should scroll down if it was repeated. I love that you guys have so much great conversation though. But I'm not finding anything from Robert. Oh wait, all the way up here. Okay. I think, right? Okay, let's see. Robert says, spoke with a friend in the Georgia court system earlier today. I worked a case with her 15 years ago. She told me that the judge is under judicial review as of the 14th. The judge will be removed. I'm not surprised at all. Is that coming from probably the Judicial Qualifications Commission? I forget the specific name every time I think of it. But I know they have a public meeting think it's the 21st, which would be tomorrow. But my brain is skipping days. I had a really busy week with day job stuff this week. So my brain's kind of fried. I want to say it was the 21st, which would be tomorrow. But they also have a public meeting, this Judicial Qualifications Commissions Board. But I'm not surprised to hear this, that they're already considering it. That might be the same body, organization that would be issuing this judicial review. I'm not surprised at all, but it's awesome that there's motion there. Because again, this writ of mandamus could be some type of remedy, but it's not a parallel remedy to what a judicial review could do, right? A writ of mandamus is basically asking, hey, we need you to get this motion to recuse. We need a hearing, and we need this hearing to go in front of an unbiased judge. That's really what this writ of mandamus is asking for. Judicial review could do a lot more right now. No waiting on an appeal. No hoping a writ of mandamus is, a Supreme Court agrees to look at it. Judicial review? Yeah. That would, if there's a judicial review and they say we want to remove him, that's now. They're not going to say we want to remove him, but we'll wait. We'll wait until this proceeding is done. So that's an incredible detail. I'm glad that you guys said go find Robert's comment up there. I know, I was going for a while and I was like, I don't see it. So I'm glad I found it. And then, so Tyrese, you must be in Australia too. Oh my God, how many guys are in Australia? That's so cool. And that's actually, okay, it's kind of embarrassing. I'm glad you're here with us. But it's like a little embarrassing that this is a worldwide spectacle, right? Everyone's tuning in around the world to see what's going on with this trial, with this judge, and, him acting in concert with the prosecution. Because again, it's not just the judge, it's also the state. So it's awesome that you're here. Australia sounds super cool. But then I'm like, oh my God, you guys are watching how bad things are in this trial. That's how far the news has spread. So that's crazy. Nita Vita, I'm just seeing you comment. Good to see you pop in. You guys, let's do, before I drag down your time here, let's do this. And I don't know. I'm trying to think to myself. I didn't do a video reading Judge Glanville's written order, did I? I haven't read this yet, I don't think. I feel like I should have, if it's filed on the 14th. I know we talked about the oral things, but I don't remember this. I think this is new. So I think we should read his written ruling, see what Judge Glanville's writing as his reasoning for denying the motion to recuse. So let's do it. And then I also saw, I'm scanning over in the chat, I did see a New Zealand. Look at you guys. You guys are all down under. Paul Carriage, all the way from New Zealand. And then order on motion to recuse Chief Judge Ural Glanville. Can you imagine writing your own name? You gotta write a motion denying the request to recuse you. It's absolutely one thing I don't know if I'd want to do as a judge. That's embarrassing. I'm sure it happens all the time though, right? As a good defense attorney, if there's even a small reason for, a possible recusal for a judge, a good defense attorney should make that motion, right? So it's not like it's completely rare. I think what's rare is seeing such a solid reason where any opinion I've seen someone talking about Judge Glanville and what he's doing, it's really uniform. It's in unison. Everyone's like, he should just recuse himself. I don't know why he's doubling down and trying to keep the train going. That's what's rare about it, is that everyone thinks it's a big deal and he should just recuse himself, and he hasn't. But now we're going to see in his words, his argument why he's not going to recuse himself. So this case is before the court on defendant Diamante Kendricks, June 12th, motion to recuse Chief Judge Glanville. The defendants filed the motion in response to the court's actions taken on Monday, June 10th, during which time counsel for defendant Jeffrey Williams, Mr. Brian Steele, was held in direct criminal contempt. Following a review of the motion and the accompanying Weinstein affidavit, this court finds as follows. So they're going to go over the details here of this ex parte meeting. We already know who was alleged to be there, when it took place, that Mr. Steele made the arguments. So Mr. Steele approached the podium, began to admonish the court for not informing him that such a meeting occurred, and argued that such a meeting is in violation of his client's rights. In addition to the court's serious concern with how this information was improperly disclosed, yeah, I do bet it's a serious concern. But the reason it's a serious concern is what's twisted about this. If it was a secret meeting and the judge wasn't there, and this stuff wasn't disclosed, the court should be concerned with something like that. But you were there, Judge. So, in addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. When the court told Mr. Steele that he needs to disclose how he came about that information, Mr. Steele repeatedly refused to answer. The court, having told Mr. Steele multiple times that he needs to tell the court how he came into the information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, Mr. Steele nevertheless refused to answer. Therefore, the court was left with no remedy but to hold Mr. Steele in direct criminal contempt. And we're getting a footnote. At the writing of this order, the Supreme Court of Georgia, he's bonded out. He's not going to jail. As a result of the court's ruling, counsel for defendant Diamante Kendrick submitted the subject motion, which was presented to the court on the afternoon of Wednesday, June 12th. Court was in session at the time that the motion was presented to the court, prior to the jury returning, but while the witness, Mr. Copeland, was on the stand. According to the motion, Judge Glanville should recuse himself due to the allegations that he held an improper ex parte hearing with a sworn witness, in contravention of Uniform Superior Court Rule 4.1, which in turn is a violation of, at least, Section 2.9 of the Georgia Code of Judicial Conduct. Defendant's main assertion is that the facts alleged in the affidavit accompanying the motion warrant his recusal, as they demonstrate that defendant and his co-defendants in this case are not receiving a fair trial as to their constitutional right of due process and under the Sixth Amendment. And now we're going to get his analysis. Judge Glanville's analysis of the request to remove him. So, recusal by a Superior Court judge is governed by Rule 25. Rule 25.1 provides in part that all motions to recuse or disqualify a judge presiding in a particular case or proceeding shall be timely and filed in writing, and all evidence thereon should be presented in accompanying affidavits. And let me get rid of this ticker I've got at the bottom, because we're not even... By the time anyone's joining late, they should know what we read earlier. And this is just bonus. So, in writing, all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for disqualification, and not later than 10 days prior to the hearing or trial which is the subject of recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. So, then they're going to go over the 3 things that must be met. So, when this type of motion to recuse is filed, the trial judge shall immediately determine the timeliness, the legal sufficiency of the affidavit, and the legal sufficiency of the grounds, and has no power to do anything else in the case. And we're getting this... We're citing Robinson v. State, which relied on the Baptiste v. State decision. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it was timely filed, whether the affidavit made in support of it is legally sufficient, and whether, if some or all of the facts set forth in the affidavit are true, recusal would be authorized. And we got Dacre v. State. This kind of seems redundant, but okay. If the trial judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there's no error in denying. Accordingly, this court will address each of the 3 threshold conditions. So we're going to skip timeliness of the motion. We know it was timely. Legal sufficiency of the affidavit. This I want to read in case he says anything spicy as he says it. Turning to the second determination that a trial judge must make when presented with a motion to recuse, Georgia courts have held that the affidavit accompanying a motion to recuse must contain 3 elements that are essential to a complete affidavit. A written oath embodying that the facts are sworn by the affiant, the signature of the affiant, and the attestation by an officer authorized to administer the oath that the affidavit was actually sworn by the affiant. Upon review, the Weinstein affidavit contains all 3 elements, the written oath, the signature, and an attestation by a notary. Accordingly, the court finds that the second threshold was met. Now 3, legal sufficiency of the grounds. Turning to the third determination that a trial judge must make when presented a motion to recuse, it is not enough that the affidavit simply meets the above 3 elements for legal sufficiency, as it must also, quote, fully assert the facts upon which the motion is founded, and present all evidence on the motion. So, under Rule 25.1, here, the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. So we saw that part quoted in the writ of mandamus. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of the judgment. The facts and reasons it states are not frivolous or fanciful, but substantial and formidable, and they have relation to the attitude of the judge's mind towards defendants. The affidavit must contain definite and specific foundational facts of the trial judge's extrajudicial conduct, demonstrating a purported lack of impartiality, and are not stated in conclusory fashion or as a matter of opinion. Allegations consisting of bare conclusions and opinions, that the assigned judge is biased or prejudiced for or against a party, are not legally sufficient to support a recusal motion or to justify forwarding the motion for decision by another judge. Now this specifically right here, the other stuff seems like it's more applicable to an actual decision, not just a consideration of a recusal motion, but an actual decision on whether or not to recuse, force a recusal. But here, this quote, this idea that the issue at the heart of these motions to recuse is bias or prejudice. Maybe that's part of it in some way, but at the core, the issue is the misconduct. This ex parte meeting took place. It wasn't disclosed. You tried to suppress it from us. You're trying to keep these transcripts from us. You slid documents in front of witness Woody Copeland that, quite frankly, looks like you're trying to coerce him to testify, which isn't just a simple bias, but it's acting in concert with the state to get a witness they need to testify to agree to testify with your help. That was what the core of these motions to recuse were about. Not just a general claim of, oh, you seem biased or like you're making unfavorable rulings. But, Judge Glanville seems to argue with arguments that he invents for himself to argue against. So then they're citing Baptiste v. State. This is where he's relying on Baptiste. Let's see what it says. That's supposed to support his argument. In order to be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case. And that's United States v. Grinnell, Burt v. State, Carter v. State. The alleged bias of the judge must be of such nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. Well, what if the key witness is the one being influenced? Jones v. State, Burt v. State, and all these underlying cases round up into Baptiste v. State. The facts alleged in the Weinstein affidavit that are pertinent to a discussion of whether Judge Glanville engaged in activity meriting his recusal are those of which Affian identified as occurring under Weinstein's information and belief. However, there is no indication of where the information on which defendant relies came from, and therefore no way to verify its veracity. Your job, judge, is not to verify the veracity at this stage when you have a motion to recuse. Holy moly, is this really in writing? Oh my gosh. So he's saying there's a lack of evidence, but a sworn affidavit, even if what's being alleged is preceded by under information and belief, it's still evidence. The veracity of that can be weighed at some stage at some point. But as far as that affidavit being attached to a motion to recuse and given to Judge Glanville, at that stage, the veracity of any underlying statement in the affidavit, the purpose of that motion to recuse is not to actually figure out, is this true? Is this false? It's just to say, if we accept it as true, should I say, okay, this reaches what's necessary under Rule 25.3 for me to set a motion to recuse hearing in front of a different judge. That's all. So this argument is whatever. I'm not surprised. I'm really not surprised. The Weinstein affidavit offers no actual evidence to support these facts or any actual evidence as to the extent of the discussion that took place during the ex parte hearing, other than the bare allegations made by affiant. As such, the court does not find that these facts give fair support to the charge of a bent mind that may prevent or impede impartiality of judgment. Further, these facts are not definite and specific foundational facts of extrajudicial conduct demonstrating a purported lack of impartiality, but are nothing more than mere allegations stated in conclusory fashion. So now you're saying it's conclusory. So you just called him out for using the verbiage under information and belief. And now you're mad. You're framing those same allegations as if they're being stated in conclusory fashion. Which one is it? Which one is it? They do not support a finding of an extrajudicial source causing the undersigned judge to have an alleged bias that has resulted in an opinion on the merits other than what he has learned from his participation in the case, nor do they demonstrate that the undersigned judge has shown bias of such a nature and intensity to prevent the defendants from obtaining a fair trial. And there's also, I do take a little bit of issue with this. He said this more than once. I'm not forming an opinion on merits other than what I've learned in participation in the case. Now, part of his rules as a judge, he's not supposed to put himself in a situation where he could come across information relevant to something substantive in the case that hasn't actually come into the case, that isn't actually on the record. And when he was first confronted last week by Brian Steele, when Brian Steele made that inquiry, he was like, where were you? Did you just have this meeting? And he's like, oh, there's nothing wrong with it. It's recorded. So it should be fine. All right, well, can you give us that recording? Can you give us the transcript? So he's denying the record to the defendants. So in a way, he's forcing himself to have information that isn't available on the record that's available to the defendants, all of the co-defendants in the case. So I take issue with him saying, he said this earlier in the order too. Yes, you learned about this in your participation in an ex parte meeting. That technically should be part of the record if you stop holding the transcript hostage. But as far as accessibility, it's essentially not part of the record because the defense can't access it. So this has problems too. This guy. What an interesting guy. So he also says, nor do they demonstrate that the undersigned judge has shown a bias of such a nature and intensity to prevent the defendants from obtaining a fair trial. And in conclusion, if all three conditions precedent set forth in Rule 25.3 are not met, the trial judge shall deny the motion on its face as insufficient. It is as much the duty of a judge not to grant the motion to recuse when the motion is legally insufficient as it is to recuse when the motion is meritorious. Since the affidavit accompanying the motion for recusal on the grounds set forth herein were insufficient, the motion for recusal was improperly denied by trial judge without assigning it to another judge for hearing. Now, this is really what I think Weinstein's the writ of mandamus was getting at. By saying that the statements are there, but there's no evidence to support them. It's the implication there, the inference you can draw is, well, the statements are enough. The statements are present. The sufficiency of the evidence by any other person's standards, besides Judge Glanville himself. These things are good enough. But Judge Glanville's adding a standard that doesn't exist. He's adding in that they must be verifiable. That at this stage, it's him that gets to determine the veracity before weighing in on this motion to recuse. So when Weinstein was saying earlier, really all three of these requirements were met, even though Glanville's saying they weren't met because, veracity wasn't determined, really the elements that are supposed to be met are actually met, and Glanville made up a new standard. What an order to put in writing. So in conclusion, in applying the analysis required for motions to recuse as set out in Uniform Superior Court Rule 25, and further clarified by Georgia case law such as Baptiste, Robinson, Dacker. The court finds the plaintiff's motion and affidavit have not met all three of the threshold conditions. Therefore, the motion's insufficient on its face. So now he's switching to the on its face, the prima facie consideration standard. He's switching back to if we just accept it at face value. While he wrote a whole paragraph saying it's actually not met because we haven't verified the veracity. And the court does not find it necessary to refer the motion to another judge, so it's hereby denied. And this again was the 14th day of June. Guys, what the hell? This was bad for a few reasons. I mean, okay, I guess in part there's a small explanation here that he could be working from a template and just like plugging and playing certain pieces in. So this part might all be from a template, which is why it's contradicting what he actually wrote himself as his own add-in argument, his own improv argument is what we're going to call what he does, right? So he might not be the one coming up with these words. This was templated, probably. But it still sits right there. It's right in front of his face. He could have realized it was contradictory and tried to present his additive argument in a better way. And he did it. He really did it. So, like, come on. And it really seems like he doesn't understand the law. And that's scary because he's been a judge for a good amount of time. Like, that's crazy. Yeah, definitely strong. Are you serious? Like, this is just crazy. And hold on, I have a you are onto something coming from Drea. And then Commissioner Sleer says, repeating myself, I'm not sure he wasn't just trying to speed the trial up by forcing a witness to testify and was too stupid to realize it was against the rules and would blow up. Yeah. Yeah. The idea that, you know, are we lacking intelligence? Do we not know he doesn't understand the law? So that is a very good possibility. And his way of dealing with it is maybe when the pride is getting in the way now. So what we're seeing as a second leg is pride preventing him from stepping aside and letting there be some proper remedy. You know, he had an off-ramp. He didn't want to take it. So, yeah, and Alex Kintner, that is a great other point, too. So mere accusations that he can't judge the veracity of, but he was there. He should know it's accurate. And he said the same thing to Brian Steele on the 12th? Maybe it was on the 10th. It was either the 10th or the 12th, but it was to Brian Steele. He was like, we don't even know if what you're saying is true. But you were there. You would know. Brian Steele might not have firsthand knowledge, but you would have firsthand knowledge because you were there. So, and yeah, Tamika Jones, like, next time he wants to file a BS motion, he should let us read it first. Can you imagine all the red lines, like, you know, the teacher writing on the essay correcting things? Like, just crazy. And that part too, you're hiding behind, you don't want to release the transcripts, like, just, it's a mess all around. I did want to see, let's see, Exhibit C, this affidavit of Lester Tate. I think he's going to, this is probably going to be supporting why he wants, oh, this is kind of long. Let's see what it says at the end. That's only 6 pages. Because I think this is just a statement from someone saying, like, look, I know law, and it's in my interest to let you know that I think this writ of mandamus, you know, there's smoke and fire here. You should consider it. Yeah, let's check out this. It's 6 pages. Let's see what it says. And then hide this comment, make the screen giant again. And then comes now. I don't know what the S stands for. We're just going to call him Lester Tate III. Personally appearing before the undersigned, and who, upon being sworn, states as follows. I'm over the age of 18 years. I'm making this sworn testimony under oath. I'm suffering from no legal disabilities, and I'm competent to make this affidavit. and it's based on my personal knowledge of the facts herein set forth. I'm the owner of Cartersville-based law firm, Lesser Tate Law Group. As to my experience and qualifications, let's sum this up. Trial lawyer of 36 years, served as the 48th president of the State Bar of Georgia. I hold a bachelor's degree from Georgia Institute of Technology and a law degree from University of South Carolina. He's been a courtroom lawyer, having tried over 100 civil and criminal cases to verdict. I have been inducted into the American Board of Trial Advocates, one of the nation's most prestigious trial lawyer organizations, with the rank of advocate because of my extensive experience. I have previously served as the president of Southeastern Chapter of the American Board of Trial Advocates. Well, that's a long acronym, CBOTA. President of, let me hide this comment, sorry, blocking the view. President of the Georgia Chapter of ABATA and National Treasurer of ABATA. That's a lot of positions. He sounds busy. Additionally, I'm a fellow of the International Society of Barristers, the International Academy of Trial Lawyers, and Senior Fellow of Litigation Council of America. I'm licensed to practice in Georgia and admitted to practice in a number of courts, including the Supreme Court of the United States, the 11th Circuit Court of Appeals, and the U.S. District Court for the Northern and Middle Districts of Georgia, and all Georgia state courts. I've been admitted pro hac vice in other jurisdictions, and have never been subject to any disciplinary action by any state bar concerning my provision of legal services in any courts. He served as vice chair and chair of the Georgia Judicial Qualifications Commission between the years of 2012 and 2016. Since 2016, I have regularly represented and advised Georgia judges from all classes of courts in cases involving judicial ethics and the application of the Code of Judicial Conduct to their service. Accordingly, I have developed a particular level of expertise with all aspects of the Code of Judicial Conduct, including provisions which relate to ex parte communications by trial judges and standards for recusal. So further, my civil and criminal experience has provided me with extensive insight into issues which may arise at trial and how those might be handled. While I have not attended any of the trial in the state of Georgia versus Jeffrey Williams and all, Fulton County Superior Court case, and they give the number there, I have watched various video recordings of the proceedings, including the exchange between Judge Glanville and Brian Steele, in which Steele raised the issue of an ex parte meeting with a witness, the witness's lawyer, and prosecutors. This in-court exchange ultimately led to Judge Glanville holding Steele in contempt of court, an order which has now been appealed to the Georgia Supreme Court and stayed pending resolution. I have specifically reviewed the order holding Steele in contempt of court, attached here to as Exhibit A. So by Exhibit A, I think they mean attached to this whatever he's writing, the sworn affidavit that he's writing, and the show cause order issued by Judge Glanville directing parties to the ex parte meeting to show cause why they should not be held in contempt. The opinions I have expressed in this affidavit are based on a review of those video clips and a review of the attached exhibits. I express no opinion in this affidavit that is based on any ruling. Oh my gosh. They are all coming at Judge Glanville for saying that this motion to recuse has anything to do with, oh, you're unfair, Judge. No, it's about misconduct. So Tate here, Tate the Third, is saying, I express no opinion in this affidavit based anything on a ruling made by Judge Glanville. Instead, my opinions herein are based solely on his conduct in failing to comply with the Code of Judicial Conduct. Based on the show cause order, it is now apparent that an ex parte meeting took place in Judge Glanville's chambers on the morning of June 10th. This meeting is specifically referenced in the show cause order, in which Judge Glanville directs all participants in that meeting to appear. Since I do not know for certain what took place in that meeting or why it was necessary, I am assuming, for purposes of this affidavit only, that there was a legitimate purpose for the meeting that is allowable by the Code of Judicial Conduct. In other words, I'm giving grace to Glanville and the prosecutors and any other parties that called this meeting. Rule 209 of the Code of Judicial Conduct recognizes that, from time to time, there may be need for ex parte communication. And this is the pertinent part, we've heard it before, but let's do it again because this is what this affidavit's all about. A. Judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. So what could be an exception? Where the circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provision promptly to notify all other parties the substance of the ex parte communication and gives the parties the opportunity to respond. So what does Tate say? He says this rule, however, also requires, in unequivocal terms, that any judge who has an ex parte contact must promptly notify all other parties of that communication and give them an opportunity to respond. Failure to follow this procedure is a violation of the Code of Judicial Conduct, irrespective of the reason for the ex parte communication, and regardless of when the contact occurs. In other words, the judge must give prompt notice of communications that happen in trial and in some other context than outside of trial. I would further note that Rule 29 has implications beyond judicial discipline. The heading of the rule is, quote, and headings usually give the stated purpose. It's like, the title of your essay for school. Assuring fair hearings and averting ex parte communications. That's great. I don't think I've read that heading of the rule. I've looked at the rule a million times, but jumped right to what it says. But it's meant for assuring fair hearings and averting ex parte communications. Therefore, a violation of this rule is not just something that a judge could, quote, get in trouble for. It is also a rule that assures the parties to a case get a fair hearing. In reviewing the video of the exchange between Glanville and Steele, there was no disclosure of the ex parte meeting, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Rule 211 provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to ensure a fair hearing, and who also has actively attempted to conceal the meeting. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true, would require recusal. Again, I reach this conclusion based upon Judge Glanville's actions, not to any ruling that he has made in the course of this trial. So, Lester Tate III signs this on the 17th day of June, so that would have been on Monday this week. So that's actually really interesting if you ask me, and I think, what is this, a show cause order, motion to quash? Cool. Now that's really interesting to see because it's essentially, this is like an expert witness attorney with all this experience. I mean, let me go back up to, his 2 paragraphs of qualification aren't just, I took an online class and then I took another online class. He's like, I've been to trial court for 36 years. I've been president of the bar, the Georgia bar. I've done all these things, right? This is like a seriously credentialed person to give legal expertise on interpreting what this code, 25.3, what this rule is supposed to say. Like, that's that just shows you. I mean, we're in here and we're like, we don't have confidence in this. We're looking at this. It seems like what Judge Glanville's doing is fishy. But you've got all these attorneys all over the place. Even the one that you'd put as president of the bar. Like, bro, this isn't how the rule's supposed to work, Judge Glanville. It actually says the opposite, and it looks like what you're doing is denying someone a fair trial. So, yeah, I don't know. That the assure, it seems like it's supposed to be one word or the other. It's tripping with me. But yeah, this writ was awesome. Doug Weinstein, I really liked his motion to recuse. I liked the way that was written. And, let's give the other attorneys their flowers. Apt, and I'm probably saying that wrong. I don't really know how to pronounce ABT. I want to say it's like apt, but with a B. Apt. So Jay Apt and Katie Hingerty. So we'll give them their flowers too, because this was written by them as well as Doug Weinstein. And I think Doug Weinstein was feeling sick, so, maybe they really carried the weight writing this, but I enjoyed reading it. And then what else are you guys thinking here? You guys are all talking about writ of mandamus. And DJ Naptown says he knows he is above the law. And yeah, Rubber Toe. So we read Alex Kittner's comment earlier. Rubber Toe is agreeing here that I know Glanville is acting as if he's some unknowing, uninvolved third party. Like, oh, I don't know. I just want to be fair because I don't really know everything. But you were there. You were there. So, oh my god, this was crazy. I really love that they included all this stuff as exhibits. I don't know, was there, sorry to scroll like super fast on your screen. I don't want that to make anyone dizzy. But what else do we have? Let's make sure. This looks like the Weinstein affidavit. Got anything else in these exhibits? Because if it's just the affidavits and like the order to show cause, we've read all that. We won't go through that again. Um, but that statement from Tate the Third, and the written order from Judge Glanville that, surprisingly was nothing impressive but hilarious to read. Okay, cool. So I think, yeah, this is all just repetitive then. Just wanted to make sure we weren't missing any juicy exhibits in there. Do you guys have any closing thoughts, though? I enjoy, the writ of mandamus. That's what we were looking for all week. Let me get this motion to show. Let's go back up here so we remember what we're talking about. But this is really what we were talking about. And thanks to you guys in the chat, you guys have brought up, talk to someone who's down there. It seems like judicial review is underway. Removing him could come from the judicial review side, not necessarily the Supreme Court looking at this writ of mandamus and saying, yes, we're going to order Judge Glanville to schedule this motion to hear the recusal motion, and it has to be heard by another judge, and we'll wait for that to play out. Seems like, based on what you guys are saying in the chat, there's this leg going the Supreme Court route with the writ of mandamus, but then the judicial review is also in motion. So really, really fast action here. And that could be because it's such a high-profile case. So many people, even people in Australia and New Zealand, are tuning in to pay attention to it. So Kushi, if you want to... So we read through the writ of mandamus, but as part of the attached exhibits, they also included two things that we haven't looked at before. So Judge Glanville's written order denying the motion to recuse. We heard him deny the motions to recuse orally in court, but in the written thing, we went through that, and it was kind of funny to read. And we also just looked at a legal expert giving his opinion for the Supreme Court to consider this writ of mandamus, suggesting that based on his very extensive accolades, that Judge Glanville is not following what Rule 25.3 requires of him, let alone the other standards of judicial conduct in Georgia. So two really interesting things were attached as exhibits in that writ of mandamus that we just got done going through. So if you rewind like 30 minutes, you'll be able to go through that in full. And then, oh my god, Merritt Island! Shout out to Brevard! No way! We're close. We're close. And then let's see. Wait, Granville? It's Glanville. Are we talking about something different? What's Granville with an R? Like Grandpaville? Why are we getting Granville? And yeah, okay, so Drea says that Weinstein speaks exactly like he writes. I can hear his cadence. He's the one, guys, in my opinion, he sounds so polite. He cautioned before he called out in open court. He's like, I really don't want to say this, but it seems like there might be an appearance of impropriety here, Your Honor. Like, he was like really polite, very punctual. I like the way he speaks. I get entertained by Brian Steele running up like a little firecracker too, but I like it all. I like good lawyering no matter what the personality behind it is, but I always think the personality behind it's really interesting too. It gives that unique flair. Let's see. I'm going to round this up though. I do want to... So Jody says, I believe the state thought that because it was Kayla, who used to work for the DA office, was standing in for Woody's attorney, they thought they were safe to have that secret meeting, right? I've seen that too. Like there's some unspoken trust that was expected there, possibly. And then guys, so Jody might already be aware of this, but in case anyone hasn't heard about it, Kayla Bumpus spoke with Talk That Law on the channel Talk That Law and said, look, there were 14 people in that meeting. And I've seen all these guesses from people about what happened with the ex parte meeting. And the guesses really haven't been right yet. So it seems to me she's suggesting it wasn't me that leaked it, because that's what everybody's guessing. It wasn't me that disclosed it. I don't want to say the word leak, because it's really a disclosure. It's not a leak. It's a disclosure that should have been made by the prosecution, if nobody else. But the judge shouldn't have been working in concert to keep it hidden, denying these transcripts of the meeting, all of that stuff. So when Kayla Bumpus gets on and says all these guesses are wrong, it's kind of like, was it the court reporter? Was it a deputy? Who came out and said something? Was it Hilton? I did see a few guesses saying they think it was Hilton because Hilton looked upset and like she was crying in court that all of this was happening. But I don't know. But according to what Kayla Bumpus said with Talk That Law, she seems to be pushing back on the major guesses that it was Woody or her who came out and disclosed it all. So who knows? And I'm not saying she deserves to be in trouble for disclosing something. I think that's a separate issue that Judge Glanville's trying to infer that doesn't really hold water either. But in any case, you know, we're here running wild with our theories out here, and I'm curious to see what really happened. What else do we got? Hold on. Shout out to Nino Brown. Shout out to Big Trelly. He sounds like the devil character in some RPG software. You know those video games where you have to read it? They don't have voice actors yet, so you can just make up whatever voice you want for it. And then Nino's all the way in the Cayman Islands. That's awesome. That's awesome. Shout out to you. And then Deborah says, sounds like the board game of Clue. Oh my god, how many pieces are on each Clue board? That'd be so funny if it was actually 14 pieces, too. Yeah, Kayla's just giving misdirection. That's obviously a possibility, too. That's fair. I hope, okay, so Christian Love says, she said that the meeting next Tuesday may not take place. I hope it doesn't. It sounds like a waste of time. Like, what were they exactly being held? What order did they violate that they need to show cause for violating? Nobody was given an order. I really enjoyed the motion to quash. But yeah, let's wrap this up. We'll wrap this up with Roberto saying evil things nicely, and shout out to Drea. You guys show Drea some love in the chat. She became an impromptu mod, and I appreciate her so much for it. But she also has a lot of great conversations with you. She's so polite to you. So everyone, say hey to Drea in the chat, because I appreciate you personally, Drea, but have some manners in the chat. Show Drea some love. Stop. Stop. It was Judge Glanville in the library with the candlestick. You guys are really gonna take this Clue thing to like a full-on like role-playing game. Like the fan fiction. Oh, it's so funny. And then yeah, look at this Drea love flooding in. There you go, guys. That's what I like to see. And then yeah, I can't help but get into it. I'll keep an eye out for, you know, what's going on. Again, this was Kathy Roussan. She's been in the courtroom covering some of this. She had posted the full order on X, so I know I usually shout out Thugger Daily, and still do. Super prompt with updates with Thugger Daily. But Kathy Roussan was the person who grabbed this motion today, so super shout out to Kathy on that one. And then you guys all take care. Thanks for showing Drea some love, and thank you, Drea. Bye, you guys. Have a good night.